Thank you so much for joining us, and thank you to Josh Normanton for joining. What we're going to cover today is, so first of all, have just a brief discussion on why CBD flower is such a hot topic at the moment. We'll be looking at what the UK legal position is. We'll be covering international law and the relevance of that to the domestic market. We'll be giving detailed advice on what to do if you are already in trouble with the police for selling hemp flower. So if you're under investigation by the police, we'll be giving you some advice on what you can do. If you've been charged, then we'll go through what your available defences are. We'll look at why being prosecuted and why being convicted for hemp flower offences is such a big problem, and that really goes to the POCA proceedings that can follow a conviction. And we'll also be talking about the future for UK and the CBD flower market. Okay, the boring bit, the actual law, and this is why I got Josh on to speak about it, because he knows it better than me. So the Misuse of Drugs Act, 50 years old this year. Is this definition of cannabis still fit for purpose, Josh? So first of all, the Misuse of Drugs Act implements our international obligations under the UN Convention, which we will come on to as well. But here is the definition of cannabis, okay? And the important part to note is, well, in my opinion, is that they specifically highlight parts of the plant which are not controlled, so meaning everything else is controlled. And there's no mention of THC at all in this definition of cannabis. Is that right, Josh?
That is right. And if you're in the CBD industry, you might argue this definition is not fit for purpose. But that is because it is quite old law, and is not anticipating the development of the CBD industry as it is now. You're right in the sense that there's no definition here of cannabis which reflects a chemical composition. If you possess, supply, import anything which falls within this definition, flowers and leaves, then very likely you're committing a criminal offence.
This basically forms the basis for the position that the police and the CPS are currently taking.
Yeah, and that's right. You know, Parliament decided off the back of a set of really two treaties by that point that it was going to put into effect an international agreement about preventing drug supply, and this definition imports the definition in that international agreement. The point is that an international agreement is all about stopping dangerous or otherwise harmful drugs, and I don't think the CBD industry wasn't even a twinkle in anyone's eye when this definition came into place. Yeah. And it frankly criminalises the possession of CBD flower.
Yeah. Okay. So moving on to the European position, got a little graph here from our friends at New Frontier Data. It's quite an old one. So everyone goes on about 0.2%, and it's been a common misconception here in the UK that if your flower has less than 0.2% THC in it, then it's perfectly legal. Unfortunately, that's not the case. The 0.2% rule from the European perspective relates specifically to cultivation. And that does not flow through to extracts, and it does not apply to hemp flower being sold here in the UK anyway. So obviously there's lots of big lucrative hemp flower markets in Europe. Some of them have to be sold as non-smokable products. Some of them are openly sold as smokable products, and some are marketed specifically as a healthier alternative to tobacco. So we are a long way behind our European counterparts in that respect. This is the OG of narcotic control, so the single convention here. And the definition here is a little bit different from the UK definition. So it talks about the flowering and fruiting tops of the plant. And then it goes on to state that the convention shall not apply to the cultivation of the cannabis plant purely for industrial purposes or horticultural purposes. Josh, can you just give me an idea of how much notice do British courts and British regulators have to take of international regulations? Do UN conventions and EU regulations still have any weight in the British justice system?
Let me try and condense that absolutely massive legal question into a few
Sorry, it's a big one.
I think the answer to the question generally is they've got to take it into account if it's necessary to do so. But the Misuse of Drugs Act has been in place since 1971 and is pretty clear about what it says. I think if there's a question mark over a definition, the Misuse of Drugs Act, and they've got to go that means there's a case. Still got me. There's a case called Marwahar in 2017 where the High Court was thinking about the definition of poppy straw. And in that case, they went to back to the Single Convention to try and understand what the definition of poppy straw is. But I think that example really serves to show, how rarely international regulation is likely to be used to interpret the Misuse of Drugs Act. In the case of cannabis, the definition is really clear. So it's unlikely anyone's going to be going back to the Single Convention and trying to, redefine the definition of cannabis with reference to the Single Convention. What I don't think is going to happen, which people might be concerned about in this case, is I don't think the British courts are going to go back to the international regulations to try and resolve or redefine wider public policy questions. For example, the Single Convention was really about outlawing harmful drugs. I don't think what the courts are going to do in this country is go back to the Single Convention and say, right, well, can we look again at CBD flowers because they're not really harmful, and the Single Convention wasn't meaning to outlaw them, and try and redefine Misuse of Drugs Act. I think what you need for that is you need Parliament to get involved.
Yeah.
And legislative change.
But let's say if you're using a strategy of disruption and trying to highlight confusion and inconsistencies, then you'd throw it all in there, wouldn't you? You'd get the UN convention in, you'd get the EU regs in, and try and disrupt the UK position as much as possible.
Yeah, I think you would. And there have been perfectly proper legal strategies, Rob, that you and I have adopted, perfectly proper and sensible arguments which have referenced the Single Convention and the 1971 Convention. But I think those arguments in reality only go so far. And it may be that when one gets into court, what one's trying to avoid is, in many senses, a ruling to say that it just doesn't matter. Yeah. But there is some force in referring to it when you're referring to, I think, confusion, which is relevant to the state of a defendant's mind.
Yeah. Can you just also explain the horticultural exemption for me, please? What do they mean by that in this convention, horticultural purposes?
The answer to that is I can't really tell you exactly what it means, because it's not entirely clear to me. There's not really a lot of discussion about it, apart from perhaps within kind of trade press, which I don't really see as a kind of legal assistance. My sense is it's probably more of a kind of scientific garden exemption. That was the intention, and a license to produce drugs for consumption. And of course, you can have horticultural things. You can use horticultural for eating. Article 28 of the convention says that it should apply to cultivation. It shall not apply to cultivation exclusively for horticulture. So I suppose that might mean exclusively for kind of gardening or presentation purposes rather than wide-scale consumption of the plant. And certainly sometimes see that in poppy seed cases. What it doesn't seem to me to be meaning, doesn't appear to be easily defined as permitting, say, wide-scale supply of hemp flower for consumption. I think that's a difficult argument to make. Okay.
Thank you very much. Right, that's the boring stuff over. Let's get into the good stuff. So here's the situation in the UK, okay? The police and the CPS, they do not distinguish between high THC and low THC flower. So trying to claim that your flower is low in THC and therefore it's legal is not going to work, okay? As far as the police and the CPS are concerned, it's all cannabis. They don't distinguish, right? And part of the justification for this is that they say if officers are looking at hemp flower and looking at marijuana, they are not going to be able to tell the difference. It looks like cannabis, it smells like cannabis, They do not have the capabilities in the field to do tests on cannabinoid content and that sort of thing. And frankly, they haven't got the inclination to do it. They don't care. All right. However, this is a policy that is not being applied in a consistent manner across the UK. So there is a bit of a postcode lottery to this. Some counties, businesses have even received, correspondence from police saying it's fine to carry on with what you're doing. We've got no problem with it. And this seems very, very unfair to me. If some businesses in some areas are being given the green light to go ahead and others are getting arrested and raided and all kinds of nonsense, then that's just not right. In terms of how police attention comes about, I would say there's two main ways. One is, first of all, the physical premises. The physical premises is obviously much easier to police than an e-commerce platform. And quite a common example of what happens is the police stop someone on the street who is smoking cannabis or what they believe to be cannabis. They pull out a bag of what they say is hemp flower, and they say, I bought it from that shop around the corner. And obviously the police officers go around the corner and they walk in. The second way that police are often identifying businesses which they want to intervene in is via Inception of Shipments. So as I said, people are importing this product from legitimate businesses in Italy and Switzerland and places like that. They're just using the regular post. So these shipments of hemp flower are coming into the country with DHL or UPS, and it's getting stopped at customs. And if customs see something that looks like cannabis, then they're going to notify the police. So one way that a lot of businesses avoid detection is by making sure that their shipments are not going to their place of operations and are not addressed to them personally. So those are the two ways that police attention often occurs. Josh, when police do want to intervene in a business, how easy is it for them to sort of get search warrants so they can go and search premises and home addresses? Is there a limit on how many addresses they can search?
No, I think if there's a reasonable basis because they suspect that the premises is linked to the offence. So in a case, I suppose, of a shop selling CBD flower, I'd be, if I was advising the police, I'd be saying, well, we should certainly be looking at the business and very likely the owner's the owner's house. I think inevitably those are the properties which are likely to be searched and for which there's a reasonable justification to be searched. I mean, in theory, there's no limit so long as the properties identified are likely to, bring forward reasonably are likely to hold evidence relating to the case.
Okay, so just as an example, if I owned a CBD a business on the high street and I was selling hemp flower, and the police came in and they seized my product, would they be able to go to my home address as well? Yes,
I think so. In theory, yes.
So don't hide anything in your home address either. That's not a safe place to keep it.
Well, I mean, the reality is with search warrants is more likely you're going to realise after the fact, because the police are going to go to relevant court, they're going to apply for a warrant, they're going to say they're going to have to justify to a judge that there's a reasonable basis for them to have the warrant, and then once they've got it, you're going to come to who will provide you a copy of the warrant. You'd be sensible to take that warrant almost immediately to the nearest lawyer you can find. But by that time, your home will very likely have been searched.
Yeah. Okay.
Or your business. It's difficult to stop it once it's in train.
Yeah. So, in terms of the possible charges that people are sort of having brought against them for selling hemp flower, we've got two charges here, which I'd just like you to explain to us. And I was going to do like a whole line of duty theme and all this kind of stuff, but the finale was so crap that I've just been angry and I stripped it all out. So that's why there's one line of duty pick left in there. Josh, these charges, can you just give us a bit more information about the difference between them and what the elements of the offences are?
Yeah, I mean, with the law, it often is what it says on the tin. With a few added bits on. Importation is bringing a controlled drug into the country without a license. The offence for that is actually under the Customs and Excise Act and is kind of said as evading the prohibition. Generally, importation, bringing it in, arranging it to be brought in is the more serious offence. Possession with intent to supply is, as it says, you have in your possession a controlled drug, and the evidence shows that you intend to supply it to another. That is more serious than possession.
So this is the thing, even though people aren't getting high off this product, they're effectively being accused of being drug dealers.
Yeah, and that is a really interesting debate at the heart of it. People being treated as if they are selling skunk cannabis because the offences are the same. The law is as the law is. That is a particularly harsh outcome, one might argue, when you realise that in fact the drugs, the product they're selling, doesn't in fact have much of an effect.
And are people going to cop like serious sentences for selling hemp flower? I mean, surely the court must distinguish between a product that gets people high and one that doesn't.
I think that's very much up for debate. If I was advising anyone and they were selling CBD flower, I'd be advising them, if they head towards the sentencing process, to be armed with an independent analysis of the drugs to show the low level of THC in it. Because I think that must be relevant mitigation. When I say mitigation, facts which should reduce the sentence.
Yeah.
But I mean, my overall position would be that there is one sentencing guideline. So the sentencing guideline is a document which judges have to use in sentencing people. They should use in almost every case. That does not distinguish at the moment between CBD flower and the strongest cannabis going. There is the same sentence for all of them because it's based on the quantity that you're selling. So if you're selling 100 grams, that's a far lighter sentence than being involved in the sale of, or having in your possession kilograms and kilograms. There's no distinction at the moment. So I think lawyers have to force the distinction by relying on scientific reports and things of that nature.
Sure. Okay. So look, I'm going to go through what you should do if you are arrested and are under investigation by the police. So this is before any charges are brought. So I've had a lot of success with this on a number of cases, effectively making pre-charge representations to the police. Josh, you've helped me on some of them, in fact. So what you can do if you're under investigation by the police, you can submit your own written representations. The police have to include that in their evidence file, which then goes to the Crown Prosecution Service, who make the decision on whether someone should be charged or not. So effectively, you have an opportunity to try and influence the Crown Prosecution Service before they can make a decision on your case. So what you can do is plead ignorance. Ignorance is not a defense in the law. Everyone knows this. But where there is a lack of clarity and there's a lot of misinformation about, you can say, well, I genuinely thought it was legal. I'm very sorry. Now I realise that the police have a problem with it. You can promise not to sell it anymore. I have had quite a lot of success with this. If you say, look, we're not going to sell it anymore, the police are in a position where they can then effectively say, right, case closed, job done. We've got a successful outcome here and we can move on to something more important. So often promising not to sell anymore is useful, but some people don't want to make that promise. And then finally, you should always put forward your mitigating circumstances. So, let's say you've got a young family or you're just starting a new job or something like that, put it in there. It's always quite persuasive, I think, to say, I'll be a citizen contributing, paying tax, all that kind of stuff. You're better off letting me get on with things rather than giving me a criminal record and that sort of thing. So making a submission, a written submission, a detailed written submission like that can actually be extremely persuasive and very successful. Josh, can you just give us a bit of detail about how the CPS come to a charging decision? What is it that they are looking at when deciding whether someone should be charged or not?
Yeah, that's no problem. Before I do that, I will say in your second one, Rob, plead ignorance. It might be difficult to plead ignorance if, for example, you've listened to a webinar on the CBD flower. I imagine we'll get a lot of people now disappearing. This is it's all published online. The Crown Prosecution Service has a particular way in which it has to consider whether to prosecute someone. It's called the full code test, and they consider really two things. They consider, have they got enough evidence, the evidential test. Now, if you've got a business selling hemp flower and you're making a good amount of money from the supply of it, you've probably got enough evidence for possession with intent to supply. They've then got to consider whether it's in the public interest to prosecute, which is a slightly thornier, more interesting question involving a number of different factors, including, I suppose, to an extent, the question of ignorance to an extent, also the effect of prosecution on you, various other issues, the misinformation in the market, perhaps. There are a range of different issues. It's a complex question, but that's really what they're considering it. And then they come to a decision as to whether there's a reasonable prospect of conviction. If they think there is, then you're proceeding towards the magistrate's court and probably, depending on the amount, on towards the Crown Court.
Yeah, I always think public interest is the way to go when making these representations, because, the police here are limited in terms of their resources, their funding. If you can give them a route to an easy resolution of the case and say, look, it's not going to happen anymore, it's not in the public interest to pursue it anymore in terms of costs and court time and that sort of thing, then I think they can often be receptive to that argument and move on to something else.
Just before we move on, I think the evidential test, and I agree, I think the public interest test should probably be your focus at the earlier point. Tactically, it's often not a good idea to give them too much information as to what your position on the evidential test might be. But there are some arguments you can make on the evidential test, to do with perhaps your knowledge and things like that, which then feed into the Section 28 defence, which we're going to talk about. So there probably are a few arguments you make there, but the focus should be the public interest test.
Yeah. Okay, thank you. So if we go on to what happens if you're charged, I've identified 4 areas where I think that a defence to a hemp flower charge should be structured around, and you can tell me whether you agree or not. So we've already spoken about this, the legal status of the product itself. I think arguing that the product is completely legal is not going to get you anywhere, and we'll talk about that in due course. But I think there is sufficient grounds to make a coherent argument that things are unclear at the very least, and therefore it would be wrong for the case to proceed, Second, abuse of process. We've looked at this quite closely as well, Josh, on some cases. Sometimes these investigations can go on for a very long time, months and months, even years. And the police often make, mistakes or they say things that aren't correct during the course of their investigation. And this can be used, again, to disrupt the flow of their prosecution. Capriciousness, I think this is a really important argument, and it's definitely a word. I looked it up, and what it effectively means is that the policy is not being uniformly applied across the UK. So it's at the behest of whoever's in charge in that particular area as to whether or not the policy is applied, and that's not really fair, I think, if the policy is not being applied uniformly across the UK. And then finally, the Section 28 defence, and that is where you put forward the defence that you genuinely believed what you were doing was legal, and you were acting under the firm belief that you were acting lawfully. Josh, can you just give us a bit more info about abuse of process? Is it quite an easy thing to prove? I imagine judges aren't too keen on hearing these types of arguments.
It's not. 2 and 3 both probably fall into the camp of abuse of process. So abuse of process is the court in effect saying, well, it would be unfair to try you for this because of some incident which makes it unfair. It is very rarely successful. The court rarely allows it. The area in which I think it's most likely to be permitted within this kind of, the sale of CBD flower is in the kind of police and the police policy not being applied. I think particularly if the police have said to people, look, this is legal, yeah. or if there has been something I'm looking at the moment is trading standards and the police potentially creating what they thought was a kind of legal market and allowing everyone to sell the product within a town that won't be mentioned. I think in those circumstances, one can explore abuse of process and say, well, look, the authorities basically gave the defendant the belief that this was legal. They misled him. In those circumstances, it can't be fair to prosecute it. And that's kind of what you're looking at for abuse of process. I mean, there's many different, hundreds of types of abuse of process, but that's one which I think would apply in this case.
Yeah, and just under the capriciousness point, the defence of, well, everyone is doing it, is not going to cut any ice in court.
Right.
And we saw that with the bankers. When a banker gets arrested or prosecuted for fiddling with the interest rates or the LIBOR rates or whatever, the defence of, well, everyone was doing it, it doesn't cut any ice with a court at all. So that's something to bear in mind. And just on Section 28, Josh, we're going to talk about an actual specific case where someone made a successful Section 28 submission. Can you just tell us a bit more about that, please?
Yeah, that's absolutely fine. So this is the kind of knowledge defence, and I saw someone mentioned it in the comments. And I think, getting beyond more basic concepts of, are you in possession and are you the right person identified? This is probably the defence people are most going to be looking at for trial if it's truly the position they're in. The defence, you will be acquitted if you're in possession of a controlled drug. And I'll read it from my big book. If you prove that you neither believed nor suspected, nor had reason to suspect that the substance or product in your possession was a controlled drug. That's a pretty hard test. And if reading through it, you have to prove it. So you have to show, I think, on the balance of probability. So it's more likely or not that you just didn't know, you had no idea, and you had no reason to suspect that what you had in your possession was a controlled drug. And I think to prove that, you've got to be kind of providing information about, what formed your knowledge at the time, as well as the circumstances in which you were selling the product.
Sure. Just on that, there's 2 points I want to make following that. Going to trial is not fun. It takes a long time. It's really stressful. It's very expensive. Avoid it at all costs if you can. And I'm not saying this so that I get more work out of this or anything, but you really do need a lawyer that understands the intricacies of hemp and CBD regulation, okay? Because it is a complex area. It takes a long time to sort of study it and learn it. Most criminal lawyers won't understand the difference between hemp and marijuana. They won't know about all the different cannabinoids, THC, CBD. So it's always good to have a barrister like Josh that understands the regulations and understands the issues very, very well. Right. Okay. So this is a real case that happened this year in Swansea, and Luke Datson was charged in relation to hemp flower. Now he put forward the 0.2% defence, and he said because the level of THC was less than 0.2% to 0.2%, he didn't need a license to import it. It was actually a legal product here in the UK. This did not go well, and I can say Josh and I were not involved in this case, thankfully. But the argument was made that if it's less than 0.2% THC, it's perfectly legal, and the judge just completely disagreed, and he effectively told the court that Mr. Datson didn't have a defence in law. So Mr. Datson was then left with a really difficult decision. Do I still go on to the jury and see if they will still acquit me, or do I plead guilty? So at that point, Mr. Datson pleaded guilty halfway through the trial. So I have to say, I think this defence here was argued very badly. Josh, why would a judge intervene halfway through the trial and effectively tell the jury that this guy doesn't have a defence?
I suppose a judge is obligated to, he's the judge of the law, and the jury are the judge of the facts. That's what he'll say to the jury at the start. And he is obliged to tell the jury if there's no defence in law. I mean, effectively what this gentleman was doing was trying to argue that a European regulation gave him a defence in English law, and frankly, it just didn't. There's an interesting debate about the effect in importation cases that perhaps is a webinar all of its own, but there wasn't, in my view, not a hope in hell for this chap. Perhaps the right defence was Section 28, though I don't know the particular circumstances of the case.
Sure. Okay. And here we have an actual successful defence of a hemp flower case. So January 2021, Southwark Crown Court, R versus AN. This was a chap who had a shop on Oxford Street and was selling hemp flower. He was charged with offences relating to 25 kilos of the stuff, imported into the UK for onward sale. He was openly selling CBD flower, CBD buds, and he had a full trial, and he took it all the way to a jury. And after 2 weeks, the jury came to a decision. He argued that he genuinely believed he had a legitimate business purpose for what he was selling. He thought that the material was legal. And the jury returned unanimous verdicts of not guilty in respect of all of the charges. So this is a successful application of the Section 28 defence. Josh, just you touched on it a little bit more. Usually it's for the prosecution to prove a case, but I'm assuming, as you said earlier, when you put forward this defence, you have to persuade the jury that this was really your position.
Yeah, I think you have to set the defence up. So I think you have to say, you have to prove, on the balance of probabilities that you didn't know in the way in which I described. I think the prosecution then have to disprove it, so that the jury is sure that that's not right. I mean, this is a case in which one might argue, without knowing the full facts, having the full paper, that the defendant who was acquitted was pretty lucky. The two things can be split up, though. I mean, he faced a charge for conspiracy to fraudulently import cannabis into the UK, which is the importation charge. I mean, it's a legitimate defence to that, to say, well, I believe this was for legitimate business purposes, but I think because I believe that the underlying product was legal. And then he appears to have relied on the Section 28 defence and was successful.
I'm just looking at things in the round. You've got a guy he's got a registered company, he's got a physical premises on the busiest street in the UK, openly selling the product, ordering it in from legitimate companies in Italy or Switzerland or wherever it is. His actions appear to be that of someone who genuinely believed he was operating lawfully. If you did not think that this was a lawful product, there's no way you'd set up a shop in the middle of Oxford Street and start selling, would you?
Yeah, and so being diligent, if you're a lawyer, you're looking at all the evidence to try and demonstrate the Section 28 defence, if that's what a defendant says the position is. I think that's right. I think the prominence of a business, it's either very stupid, it's very, very clever and kind of dishonest, or he just doesn't know, or he just thinks he's so sure what he's selling is legal that he just has no idea. So I think often it does help to establish all that, and establish that someone is running a legitimate business, and establish that someone is paying taxes, etc.
Yeah. I've seen a really good question in the comments, actually. If you were acquitted on a Section 28 defence, can you carry on selling?
No.
What would you get arrested and charged again?
I think the trial process would probably tell you all you need to know about the legality of the underlying.
Yeah, you're definitely not going to be able to use that defence a second time.
You would be effectively admitted by running the Section 28 defence. You're kind of saying, well, I know this is. The reality is that this is a controlled drug, but I didn't know. And I think as soon as you say that, you've got problems thereafter.
Okay.
In terms of knowledge.
Okay. So let's move on to restraint orders and POCA. Now, in my view, this is the reason why I don't like these prosecutions, and this is the reason why they have to be defended, is in 2002, the government passed the Proceeds of Crime Act, which everyone quite agrees is a fairly draconian piece of legislation, but it's been around for a while now, and we're all quite used to it. But effectively, if you are convicted then all of the money you earned from this business is going to be deemed the proceeds of criminal activity. And the court will order you to pay that money to the authorities. So effectively that money goes back into police and CPS coffers. So this is another reason why they're quite keen, I think, to take these cases on. If you do not pay back the money that has now been deemed criminal property, you could get a further prison sentence. There's a default sentence attached to a confiscation order. And even if you spent the money, or you bought a house with it or something like that, the court will still expect you to pay it back. And that's a really, really, really big problem. Restraint orders are also quite common in hemp flower cases. What a restraint order does, it's an order issued by the court that prevents you from dissipating your assets. So it freezes your bank accounts, it prevents you from moving money in and out. And the idea is to make sure that your money stays where it is whilst the case is being decided. And they can even issue a restraint order or ask for a restraint order from the court prior to being charged. So even if you haven't been charged with anything, you can have a restraint order slapped on you and all of your assets and bank accounts are frozen. Again, breaching the court's order can lead to a prison sentence. It's very, very serious. The court, it's effectively contempt of court, and you can end up in jail for it. A court can leave funds unfrozen to pay your legal fees if they think that you're going to be going to a trial and you're going to need money to pay your legal defense. Then we have seen it happen where the restraint order has been a partial restraint, but there is no obligation on the court to allow you to do this. So it's quite possible that everything could be frozen and you would have to go on legal aid. I'll tell you an interesting story. It's not a hemp flower story, but I had a client once who was a money lender. So he was lending money to people and holding charges over their properties. And he had like hundreds and hundreds of properties that he was renting out. And the FCA came after him and they issued a restraint order. And he just went to all his tenants and said, look, don't pay your rent into my bank account anymore. I'll come and collect the cash. And obviously when the FCA found out, he was up in court for contempt and he actually went to jail on this. So that's how serious a contempt of court charge can be. Josh, can you just give us a bit of information about what the position is with legal fees? Well, why would they freeze your assets when they know that you're going to perhaps have to defend yourself in court? Josh, are you there? Have I lost you for a second? Can everyone else hear me? Just nod if you can hear me.
Yeah.
Okay, that's fine.
Yeah.
All right, we might have lost Josh for a second. I'll see if he comes back. We're nearly at the end anyway, so a couple of ancillary issues which I wanted to go through because I always get asked these questions and so it's much easier just to put this information out there. Hemp tea. Is hemp tea legal? Well, Pucker seems to think so. They've been selling their peace tea for some time now. And you can find hemp tea on the shelves of lots of supermarkets. Under the UN convention, here's the definition of cannabis again. And if you look, it specifically excludes leaves. All right, so the actual UN convention does not include the leaves of the plant. So if you're making your hemp tea with the leaves, under the UN convention, I would say that that's actually a legal product. However, under the Misuse of Drugs Act, their assessment of the non-controlled parts of the plant is narrower. They do not include leaves in the non-controlled parts. So under the UK legislation, the likelihood is hemp tea may be problematic. Josh, are you there? Are you back with us?
Yeah, sorry. I just had some weird internet problem, which always seems to happen in the middle of important webinars.
No worries. So I'm just sort of giving the distinction between the convention definition and the Misuse of Drugs Act definition. And I'd suggest that the Misuse of Drugs Act definition does cause a problem for hemp tea. What's your view on that?
Yeah, I think we can also go back to restraint orders and POCA if you want me to comment on that. So sorry for dropping out on that.
No problem.
I'm interested in peace tea and hemp tea, and clients often comment on it, and it's often difficult to find out exactly what the ingredients are. I think if it does contain leaves, that is potentially problematic, but I think there are probably a number of different workarounds in that, not least the exempt product regs in the Misuse of Drugs Regulations 2001, that might be a workaround. I've not, whenever I've applied my mind to it, it's always led me there, and that's in the interpretation section of that regulations, and is a kind of carve out from regulation. But these products, the exact ingredients are often very difficult to find online.
Yeah, I mean, we get it all the time, don't we? Clients saying, well, all of these products are available in the supermarkets, so what's the problem? Why am I not allowed to sell hemp flower when Pucker is happily selling their hemp tea on the shelves?
I mean, Pucker, it looked like, I had thought that they had removed their product. Certainly large supermarkets had kind of stopped selling peace tea, and I wondered whether that was the reasoning behind it. I know Holland & Barrett put out some information saying that they had legal advice to support some of what they had been selling, but that all appeared, I haven't been asked to advise, but that all appeared a little bit suspect to me when one kind of delved into the Misuse of Drugs Act and what cannabis meant there, and I wondered how they were necessarily justifying that.
Sure. I don't advise Holland & Barrett. I'd love to, but I love their approach to the business in that they just don't care. Daily Mail can write whatever nonsense they like about their products being non-compliant, and Holland & Barrett just issue a one-line statement saying, we are perfectly satisfied that our products are compliant, and that's it. They just don't engage. Right, Delta 8. I know it's not specifically related to hemp flower, but everyone keeps asking me about it, so I thought I'd throw it in there. So Delta 8 is an isomer of tetrahydrocannabinol. Delta 9 is THC, that everyone knows about. Is Delta 8 controlled? Just going to this section of the Misuse of Drugs Act, it specifically states that cannabinol derivatives are controlled, and this will include tetrahydro derivatives of cannabinol. So I'm afraid it looks like Delta 8 is a controlled drug. And unfortunately, with it being controlled here in the UK, it also looks like it is controlled in Europe. So my good friend Marie Sanchez from France told me this. It is controlled in France, and my good friend Daniel Heyman in Switzerland also says that it is a controlled substance, as it is an isomer of THC. So no Delta 8 on sale in this country, I'm afraid. Right, we're nearly done. This is the last slide, guys. So it's been fairly negative about the hemp flower position all the way through. I'm going to try and give something positive because I really feel that there's weight to this. So recently there was a court decision in Germany which gave a really interesting decision, which appears to be in favor of a legal hemp flower market. And effectively, the judge said that matters should be looked at on a case-by-case basis, and that enforcement agencies or lower courts should look at what the risks for abuse are and whether they meet the threshold to be considered non-intoxicating products. So this is specifically support for a product which does not cause people to become intoxicated. There's no risk of intoxication, or the product is generally free of THC. The German court said that shouldn't be considered a narcotic, and therefore they could be legally sold. It's not dissimilar to what we saw in Canavape, where the European Court of Justice said that they'd see no evidence that CBD was harmful to human health, and therefore, although it may fall into the Convention on Narcotic Drugs, technically it would go against the spirit of what the convention was about, and I'm assuming that's what the German courts are saying here. Josh, is there any route to such a decision here in the UK? Because it seems perfectly sensible. If people aren't getting high off this product, then there isn't going to be any abuse. That's the expectation. So that's the end of the presentation. I just want to say thank you again to Josh for joining us. He's a really good barrister.
There's another question. What's the status of CBD flower or other processed products, oils, isolate? Does it fall in the same bucket with CBD?
CBG is non-controlled itself, but CBG flower is going to have exactly the same problems that CBD flower is. It looks like cannabis. It smells like cannabis. The police are not going to go away and test your cannabinoid content and then come back and say, oh, we're happy, it's free of controlled cannabinoids. They're just not going to do that. it would be, as Josh said, part of your defence to maybe do a cannabinoid analysis and then say to the court, look, nobody's getting high off this, nobody's getting any sort of psychotropic effect from this, and use that either as mitigation or possibly as part of your defence. But the police don't care about the cannabinoid content. As far as they're concerned, it's just cannabis.
Yeah, I think when you're looking at that, when you're determining a particular flower strain, you to look first at chemical composition is I think the wrong way around of doing it. I think you're looking at a much simpler analysis of what it is by reference to Section 37, which was in one of the first slides. And I think after that, if your flower falls within Section 37, it's cannabis from the perspective of the authorities. But I think if you want to improve your position as you start in the criminal process, I mean, really, you want to be starting the criminal process saying to police officers in interviews, I think before that, look, whatever this is the chemical composition of this means that this is not harmful. You're then able to have a much better discussion, negotiation with your lawyers, with the police, and you're more likely to get a good result at an early stage. I mean, like all things in many things in criminal proceedings, it's best to just have a strategy at the start and deploy it nice and early with as much information as you can, because you're much more likely to get a good result. When you're much further along in the trial process, all that chemical composition information is going to be good for is saying to a judge, don't send me to prison, or don't give me a bad sentence.